If you would have been pleading true or found true of paragraphs for paragraphs 1, 2, and 3, you would be facing at least 25 years to life imprisonment. And that's my.
Mr. Mendoza, as a juvenile, experienced the murder of his sister. This is
By whom?
by, I will,
Her husband.
it's, yes.
Do you need the name?
No, I just need the relationship.
He was her husband at the time.
What happened to that in that case? I'm talking about the disposition. The husband was convicted?
Yes.
And sentenced to what? Do you remember?
Life with the possibility.
And Your Honor, that being experienced by Mr. Mendoza as a child.
How old were you?
I was 22, sir.
I'm sorry, a young adult. Anyway, he was young.
How old was she?
She was 20.
Your younger sister?
Yes.
How many siblings do you have?
One other older sister, and then my mom adopted my daughter, or my sister's daughter, and another little boy after my father passed away.
Okay.
Sure.
Yeah. That incident being witnessed by Mr. Mendoza triggered severe depression. He was diagnosed with major depressive disorder in 2001.
When did this event occur?
In 2005.
And he was.
And schizophrenia in 2023, and as early as March of 24, 3 months prior to the alleged offense that he's already pled guilty to. I don't want to say alleged, but the offense that he pled guilty to. He was also diagnosed with the post-traumatic stress
Degree felony of evading arrest or detention. And the state's enhanced. The defendant pleaded true to the third paragraph, which states that the defendant committed the felony of illegal possession of a controlled substance with intent to deliver a first-degree felony, and was finally convicted on October 3rd, 2017 in the 364th District Court of Lubbock County, Texas, which was prior to the commission of this offense you're here for, evading arrest or detention with a motor vehicle, which occurred on or about June 23rd, 2024. And he only pleaded true to one allegation, right?
Correct, Judge. Abandoned the other.
One prior conviction.
Yes.
So this is a third-degree felony enhanced as though it were second-degree felony punishment.
Yes, sir.
So you're looking at no less than 2 nor more than 20 years confinement in prison.
Your lawyer represented that you've not been in trouble since you've been in custody.
Yeah.
Truth is, you've had 4 different incidents filed on you through the jail, is that correct?
Not that, I just know one.
And which one are you admitting to?
They said that I wasn't compliant. I think I stayed awake to read a book at night, and then I guess they want you to be laying down reading.
And that was back on January 9th of 2025, but you actually had write-ups for not following rules in March 2nd of 2025, November 13th of 2025, as well as November 16th of 2025.
So
Isn't that correct?
I don't know. I've never received any of the yellow pages that they usually give back for a case.
you're stating you were disciplined in the jail for reading a book? You were reading a book?
That's what.
There's certain times you're not allowed to read a book?
Yes, sir. And again,
All his reports are about rules, Judge.
Okay. Was it at nighttime when people were sleeping?
yes.
Is that it? Is there a rule at the jail that states that you sleep time is for everybody to sleep, and if you're reading a book that might disturb others? Is that
Basically,
what it is?
yes, sir.
Okay.
All right, so you only remember one of those particular matters, correct?
Yes, sir.
All right, so let's shift gears. Your lawyers presented to the court that all these issues are dealing with your mental health. We all know, because the judge is reading your PSI, that you've been in the criminal system on multiple occasions. Did you bring these allegations to the forefront in any other time that you've been dealing with the court system, sir?
The times that I've been in trouble, I've just sat whatever they had out.
So you've never made this
No,
statement before.
no, sir.
And in fact, you've gone through pretty much everything that our system has to help somebody with drug problems. You actually have a pretty serious drug problem, don't you?
Yes, I do.
You've actually gone through SAFE in 2020.
Yes.
You went through ISF in 2022.
Mhm.
You went through a program that Lubbock had called Managed Care back in 2002 to 2005,
Yes.
as well as Teen Challenge all the way back in 2003 for a 5-month period.
Yes, sir.
But yet on this particular occasion, you were in possession of methamphetamine in 0.5 grams. That's the other crime that you were charged with. You remember that?
Yes.
Were you actually under the influence of that at the time?
No, sir. I had the drugs on me, but I wasn't under the influence. It was 4 a.m. I was sleeping in my truck in Susan's driveway, and I woke up to hearing voices about my friend being assaulted at her house, and I drove to find her, and that's what happened.
So your lawyer also highlighted how well you followed all the officers' instructions at the time that you were arrested. You didn't make any type of statements at that time at all about the matters that we've been discussing so far in the sentencing hearing, correct?
Well, I just pleaded with them to not hurt me. That's the only thing that
So let's be specific. You did not say to anybody that was wearing a police officer's uniform that you were concerned about your friend that was being sexually assaulted.
No, I never had a chance to.
That doesn't appear anywhere in the records until you did this PSI, correct?
Yes, sir.
Do you have any other questions, Judge?
I want to just clarify a few things here. Your criminal history, let's just talk about felonies. There are some misdemeanors, DWI second. So you had a DWI first, a DWI second, according to the indictment, the second paragraph that was not pleaded true to, but it was alleged in the indictment that you were convicted of a 3rd degree DWI on or about November 8th, 2012. And that looks like it's in the pre-sentence report. By the way, any objections to the pre-sentence report other than what's been stated?
No, Your Honor.
Because it's made a part of the record for this hearing. This states in 2012, you were sentenced to 3 years imprisonment for a DWI 3rd. So you had 2 priors, and then you had been placed on deferred or unadjudicated probation for illegal possession of a controlled substance in 2010, and that was deferred. Then you had the DWI 3rd conviction in 2012. Then in 2016, 70 days in jail for illegal possession of a controlled substance. That must have been reduced to a misdemeanor. Is that right? Because that doesn't look like a felony punishment. I don't know
Unless
about
it was a
that.
state jail, Judge.
What had happened was
State jail.
they didn't have any evidence.
It says you spent 70 days in jail for no evidence.
It was as a 1244, Judge.
Oh,
You're going to be straight with me. You're under oath.
yes, sir.
Nobody knows more about your life than you. He's correcting you about your
There
life.
was a time that had happened where I did 6 months, and then my lawyer said that it was dismissed.
Let me say this. That's not.
This is the 70 days, yes, sir.
Is that the one we're talking?
Okay, I'm looking at this state jail felony, 70 days. Then the judgment of conviction by the court, state jail felony. It was 1244, section 1244 of the Texas Penal Code, which means it was treated, it was punished as though it were a misdemeanor.
Yes, I think he's.
But it's a felony.
Yes, I think
Conviction.
the dismissal is what,
I know you're doing your best you can to explain it, but that's not the way he said it. And nobody, you and I, he knows more about his life than we do. But be careful. You're under oath here.
Yes, sir.
So we're going to go through this. So that's a second felony, this controlled substance. Then we've got in 2017 attempt to take a weapon from an officer. And that was 225 days in jail. Was that another 1244?
It was.
It was. So that's a third felony conviction, not counting the 2017 10 years conviction. So this is, another 1244 conviction. You were punished as though it were for misdemeanor punishment, but you were convicted for a felony, a state jail felony. So that's 4. So you got 4 felony convictions. And here you are with me. Yeah, okay. Yeah. So and this earlier illegal possession of a controlled substance out of Hale County, Texas, did you complete that probation without being revoked? In 2010?
Yeah.
Did you complete that or was that revoked? It doesn't show.
I ended up doing 2 years state jail for that. When I got this down there.
okay.
So that's a 5th conviction, right? 5. So criminal history and the circumstances of a crime are all the basis of what punishment shall be. That's the theory of punishment, and using those basic parts into the formula. So here in this event of evading arrest or detention, the police arrest you and you're acting bizarre. And they've got this crystal methamphetamine on you. You don't think that has something to do with that?
I didn't run because of the drugs, sir.
Okay. Where'd you get those drugs from?
Giving a ride to
No. Who did you get them from, sir?
From somebody, a homeless person.
A homeless person, unnamed homeless person who's just giving out crystal meth to people?
I was giving a ride.
Every polygraph in this town is ringing right now. It's so unbelievable. This isn't believable.
I was going to some other place, sir.
No, I'll tell you where you're going. You're heading to prison here. You're not being truthful. Of course, crystal meth makes people act goofy.
Yes, sir.
You've got it on you, but it's something else. And you can't even tell us who you get it from. That's how forthright you are at the time of sentencing. You got 5 prior convictions, and you're asking for mercy? Final, let's move forward here.
Yes, sir.
From the defense, what are you asking for and what the state's asking?
Probation, Your Honor, that the court would be so kind and merciful.
Do
Judge, I'm going to
Given
ask for,
something, you're doing the best, she's doing the best she can, but she's trying to
Your Honor, I would point,
making something out of nothing here. You got to give her something to work with.
Your Honor, I would point out that, and it's no excuse. Absolutely, it's no excuse. But
That's not going to get it on.
it is very common for persons involved or dealing with mental issues such as schizophrenia, post-traumatic stress disorder.
When was,
You know, that they medicate, they
when was he ever
self-medicate.
diagnosed with that?
When?
When was he just diagnosed with that? Yeah.
So in the very beginning, well, 2023 was the schizoaffective disorder. It was official. That was the first note that I have in the medical records when he started receiving services. The
But he
major
was, where was he at that time? In jail? Wasn't he?
And, no, Your Honor.
No? Were you?
He was on parole. He was on parole. He's set to finish in February 2027. Is that correct? But it's very common, Your Honor, for people that suffer from mental diseases, because they are diseases of the brain, that they self-medicate. And
And when were you diagnosed with that?
an excuse, but
2023.
Okay.
he was
All right.
so
Oh,
diagnosed.
hold on with that. Hold on with that thought. We're going to go to the
Okay.
pre-sentence report. And I want everybody to look at page 4.
Okay.
Substance abuse history. Cocaine. Age at first usage, 19. Date of last use, 2006. Frequency, daily. 6 years of daily cocaine use, and it's some other psychological problem that's affecting him. Not daily for 6 years cocaine use, plus throwing in the crystal meth that we've got him on. And that's some kind of other basis of his psychological problem.
Your Honor, he
You
was-
can't be on daily cocaine use
Right.
for 6 years and not have some kind of psychological adverse effect.
Your Honor, in 2001, he was also diagnosed with major, and this was in 2001, major depressive disorder and bipolar 2. And that was all the way back in 2001.
Yeah, but that's when he was using cocaine every day.
I know, Your Honor, and again, like I said, I'm not making an excuse.
Where were you getting that every day? How do you get that every day? You can't, how can you afford that for years? Where were you getting that from?
I was working, sir,
No, that's not the answer. Where were you getting that new drugs from?
from a drug dealer.
I'm sorry?
From a drug dealer.
The unnamed drug dealer, the quotes around the unnamed drug dealer. The same guy for 6 years? Or lady? I don't know.
Yes, sir.
6 years. Where were you getting the money from for that?
I worked,
You made the choice every day for 6 years.
sir.
You know how many days that is? 365 per year for 6? 2,000 days in a row? You couldn't figure out the right choice to make?
It's been a struggle, sir.
Your choices are your struggle, your own choices. You know right from wrong, right?
So,
Okay, and then we're not even talking about the crystal meth that you get caught with at the scene of the crime here. Okay, all right. Look, this is years and years of consistent wrong choice making that we all, as adults, know better.
yes.
And we pay the consequence when we made the choice. What? You're asking, your defense is asking for probation. What state said?
15 years is what's warranted, Judge.
All right,
When
Mr.
we look at, I'd like to point out that factually, this man ran from Vidor all the way through on I-10 all the way through the heart of Beaumont till the very end, where he didn't stop. The law enforcement had to use means to disable his vehicle. We're lucky no one died in all this, and those are facts out of this particular offense. This plea came after 2 years of it sitting around with him exercising the right for trial, which is absolutely fine. But part of the preparation of getting ready for trial was the reviewing of all the media that takes place. And there was no indication this man was under some mental health breakdown from my perspective. If there was evidence of that, I would have had concerns about that going forward in the jury trial, which is why I highlighted that nothing was said to these law enforcement officers. Nothing was said until we get down to let's see what's going to happen with punishment. This man was using drugs, admittedly, in this PSI up until the time that he was arrested. The only thing he didn't admit to was the cocaine that you talked with him about. We have done everything we can to help this man with this system before he got here. And it's failed. It's failed miserably. And that is why I'm strongly opposed to the concept of giving him another break. He's already gotten 2 state jails that were dropped down to county jail time. Probation to me is a joke. I appreciate the advocacy, but it's not warranted here. What the PSI officer does properly point out underneath the quote-unquote recommendations, the last sentence, first paragraph, given the combination of these factors, the defendant appears to require a high level of structure, accountability, and treatment-focused supervision to address the criminogenic needs identified during this investigation. We don't see those words very often, Judge, and you and I have read a lot of these PSIs. That tells me that in the most kindest words they can say is that.
This is case number 17CR33660, the State of Ohio versus Justin Spicer. Mr. Spicer, before the court on his application to seal his record.
Probation's not appropriate for him. She then goes on to explain the reason for that is because of his his repeated justice involvement, persistent substance use concerns, and she also details his mental instability. They're using it as a crutch today. I don't see anything that warrants some mercy here. Even the comment that the officers were aggressive about how they took him down, that's inappropriate. These officers did everything they could to keep the citizens of Jefferson County safe. I'm trying to follow that through and asking Your Honor to sentence him to 15 years DDC.
Anything else?
Sure.
Okay. All right. Mr. Mendoza, anything else you want to add, sir, here? In this 24 CR 1769, the court finds as follows, that the defendant has pleaded guilty to paragraph 1 and true to paragraph 2 of this indictment. Paragraph 1 alleging the 3rd degree of felony of evading arrest or detention with a motor vehicle, and paragraph 3, a prior conviction of illegal possession of a controlled substance with intent to deliver, a 1st degree felony. So this 3rd degree felony has been enhanced to a 2nd degree felony. The court would note, though, that there is a paragraph 2 of felony offense alleged that was not pleaded true to, and that your attorney was able to negate that from this disposition of a punishment range if you would have been pleading true or found true of paragraphs for paragraphs 1, 2, and 3, you would be facing at least 25 years to life imprisonment. And that's why she's good at what she does. She does her best to minimize the exposure. At the end of the day, the facts of this case, even somebody well-versed, spoken like her, has to face the facts of this case. And the pre-sentence report is made a part of the record without objection. And this pre-sentence report states that you, before you committed this offense, had 5 convictions, felony convictions, and that the circumstances of this case included being in possession of crystal methamphetamine. You have drugs, which are a choice that we make, illegal abuse of drugs. You had 5 or 6 solid years of daily cocaine use in your history that had a lot to do with this event, but at the time, you were not using daily cocaine like that block of time, but there you are with the crystal methamphetamine. Back to it. You knew it was directly from the devil, and it had hellish consequences for you in the past. You went back to it. You visited the devil again. That's your choice. And when you dance with the devil, you pay the price. I just wish you would have learned a lesson back then that it leads to destruction, including your freedom. These are terrible. And once again, the fact that you're not looking at a minimum 25 years is again a tribute to the vigorous defense that you have here from your lawyer. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle enhanced to a second-degree felony punishment. I'm following this agreement, though. And this is a cap of 15 years, no less than 2, no more than 15 years confinement in prison or regular probation would be allowed if I sentenced you to 10 years or less. Your criminal history and the circumstances of this offense show that you have continued to make poor choices. You have to do better, because the next event, you're looking at 25 to life again, and it would be hard for a subsequent disposition to be less than 25 years after you've already been given a reduction from what you were exposed to as a cap of 15 years in prison.
The judge's final message wasn't just about this sentence, it was about the future. After avoiding a possible 25 years to life punishment, the defendant received one last chance to change his path. The next choice could cost him his freedom forever.
Happened today, sir.
Yes, Your Honor.
Do that. Now, these are your choices. So make better choices.
No.
This is 25 to life every time you commit a felony from here on. Okay. That is all. Next.